Hi everybody and welcome to a new video in the Generative Music AI course. Last time we looked at different generative music use cases. Today we're going to look at a quite hot topic, that is the ethical implications of generative music. This topic is very open-ended. I don't have many answers, but what I'm going to propose to you is a lot of questions and we can just think about those. In particular, we're going to look at different aspects of the ethics of generative music. We're going to look at some challenges, then I'm going to share some golden rules that I use to operate in this fascinating field, and then we're going to look also at some legal aspects of generative music and generative AI at large. If you've been around for quite some time like me, you probably have memories of the early 2000s when there was Napster, which was this web app you could go to in order to download music, and it was literally the Wild West, and it was a huge issue for artists and labels alike because of copyright infringement. At this point, we are at a similar moment in time where copyright infringement because of AI-generated music is once again a big issue. Let's take a look at copyright infringement in generative music. I'm going to ask a bunch of different questions here. First, is it fair to use artists' music to train generative models? Well, it really depends, and that is connected with the second question. Is artist consent necessary to use their music? And yes, I believe that artist consent is mandatory for you to use their music to train your models. But this is quite clear on an ethical aspect, at least for me, but it is a little bit of a gray area in terms of the legal aspect of it. And indeed, there have been already lawsuits against generative AI companies, not necessarily operating in the music field, but rather in the image. Like, for example, Stable Diffusion and Midjourney, that have this amazing text-to-image generation algorithms, and they've used copyrighted artist work without their consent, and they've been sued because of that. I don't know how this is going to unfold, but regardless of the legality of it, I do believe that it is extremely important that we do get consent, because it's a very important ethical aspect to enforce us to respect. Next, we can ask, what constitutes copyright infringement? Is it copyright infringement if I just use the voice of an artist and I try to reproduce that? Or do I need to use a whole song in order for that process to be defined as copyright infringement? Finally, a correlated question is, how can we compensate artists? At the end of the day, if we do want to train deep learning models for generative music purposes, we're going to need artist music no matter what. So we should find a way of compensating that music data that we are using. And indeed, this is not only a problem, but it is an opportunity for artists and for startups alike. And indeed, there's a new music startup called Data Mixer, which came out from the Sound of AI Accelerator earlier this year in 2023, which leverages this pain point. And indeed, Data Mixer offer on-demand licensed music datasets for music AI companies. So they're basically a gatekeeper of music data, and they work as a middle person between the copyright owner, and that could be the label or the artist, and the music AI companies, which actually need that data in order to train their models. And in this way, artists are compensated and everything is very transparent in terms of the usage of this data for training models. Let me show you real quick their website. So here you have it. So if you want to know more about them, just Google them. Data Mixer is an amazing company. Another important ethical challenge is about replacing musicians. Indeed, we should ask, is it okay to use AI to generate full compositions? And I do believe this really depends on when and in what context we create full tracks using AI. There's a distinction that I think is important to make, and it's the difference between can I do something and should I do something? Can I create an algorithm that generates full tracks Well, more or less I can do it today, but should I do it? Well, perhaps not. Perhaps it's not necessary. So I think it is important to understand the context in which we operate and then take a responsible decision. Connected with this idea of replacing musicians, we could also ask whether it is okay to use AI to reproduce the likeness and the vocals, the voice of human musicians. And I think, again, there isn't really a yes or no answer here. It really depends on context. It really depends on how we treat artists and the particular context we operate in. Another important ethical question is that connected to energy consumption. We are training generative AI models that are larger and larger, and that comes with a price, an energy price. The larger the model, the more the energy that we need in order to train the model and also to do inference. So we should ask ourselves whether it makes sense to spend a lot of energy in order to train these generative music models. And we should interrogate ourselves whether there is another way to have smaller models that are more efficient on an energy basis. So far, we've only seen ethical challenges, but let me give you something positive here, and that is my golden rules that I use whenever I operate in generative music. The most important thing that I do is keeping musicians at the center. The reason is because musicians are the ultimate receivers of the technology that I build in generative music. In order to keep musicians at the center, it is important to have continuous conversations with them. We need to understand whether and how they feel threatened, what they fear, so that we can address all of those issues and build technology together that makes sense for both parties. And finally, but very importantly, I think rather than replacing musicians, we should build technology that enhances musicians. And there's a huge opportunity with generative AI for that. For example, at Melodrive, what we tried to do in the long run was building a music AI engine that could take musicians' script, an idea what musicians had in mind, and could implement that in real time so that that musical implementation could change depending on the emotional setting of the narrative of a video game. And so this is something that's completely impossible to do for a musician, because a musician can't just live within a video game and write the music and produce the music on the fly. No, that's impossible. But having an engine that can take your high-level ideas and implement those in real time is something that actually enhances musicians. It doesn't replace them. This is the most important aspect of generative music. We shouldn't replace musicians, rather enhance them. Let me give you a little bit more context about what I mean when I say keeping musicians at the center. These are 4 important principles. It is paramount that we are as transparent as possible with musicians so that they know how we use their data. They need to have control over their data so that they can decide whether we as technologists can use their data and how we can use it. We need to get consent from musicians in order to use their work. And finally, we need to implement a remuneration methodology so that they can take advantage of the work that we do with AI, leveraging their musical data. Real quick, before moving on to the legal aspects of generative music, I wanted to remind you about the Sound of AI Slack community. There, you'll find 8,000 plus people who are interested in all things music, AI, audio. We use that community to have deeper conversations about the topics that we discuss here in the Generative Music AI course. And indeed, there's a dedicated channel that's called Generative Music AI course. It's a very vibrant and friendly community. So if you're not signed up there, I highly suggest you to join up. I'll leave you the link to join in the description box below. Let's move on to the legal aspects of generative music. By no means I want to say that I'm an expert in this. I read a little bit, but things change so much and so fast that it is really difficult to stay behind them. First, we should understand that there isn't a single general legal framework that covers all things generative music or generative AI. One of the reasons is because AI is evolving so fast that it is extremely difficult for legislators to keep up with the pace of innovation. But at the same time, we're starting to see a lot of legal decisions popping up in the EU as well as in the United States. Let me share a news that comes from earlier this year in August 2023. So a federal judge in the US said that AI-generated works cannot be protected by copyright. And why is that the case? Well, because AI-generated art tends to lack a lot of creative human input. And if there isn't creative input, human creative input, then there can't be any copyright there to protect a particular piece of art. This is extremely interesting, and I do believe that this thing probably is going to change in the future, and we're going to adapt our laws, copyright laws, depending on how the technology will evolve. But an interesting question to ask here is, when's creative input enough to qualify for copyright? So here I have an axis. Let's assume that here on the left we have 0 human input, and here on the right we have maximum human input. Okay, so let's put different use cases for generative music here, and let's ask ourselves, when's creative input enough to qualify for copyright? So on the left hand side of this spectrum, we will definitely have fully generated compositions. Well, here there isn't really much that humans do. You click a button and you get a piece of music, so really minimal input. So most likely here, there's no copyright that you can apply to the output of the algorithm. Then if we move slightly on the right, there's text to music. So you craft a description, an input, you pass it, and then the generative algorithm creates music for you. And again, I don't think like this qualifies as copyrightable because the level of creative input is not that much, or at least I do believe that's the case for the legal decision for AI-generated art. The judge was addressing text-to-image algorithms, and he came up with the idea that no, you can't copyright that. If we move to the right, we can think about the orchestration task. And so in this case, perhaps you have a piece of music, or at least like a melody, and then you want to create an accompaniment, or you want to orchestrate, create an arrangement for that. Well, there I do believe there's quite a lot of human input, so perhaps at this point the output could already be copyrighted. Then if we move a little bit more on the right, there's inspiration. So perhaps you can use an algorithm that suggests a melody that you can use as initial inspiration, or perhaps even a chord progression. So you take that chord progression and then you morph it however you want it to morph it. If we move even more towards the right, we arrive at a couple of tasks that have been there for quite some time now, and we've used a lot of technological innovations and algorithms to carry out these tasks. One is auto-tune and the other one is sound synthesis. We definitely know that songs with auto-tune are copyrightable, right? And of course, sound synthesis has a lot of creative input because you have to craft the sounds, even though one could argue that I could use sample banks and already use something like that's been done already for me. But that is a little bit of a different story because we're talking about sound constituents of a piece of music. But regardless, the point that I want to make here is that we are in a continuum of creative input from the left-hand side where there's almost zero or completely zero human input all the way up to the right hand side where we have a lot of human input. And then at some point here, we'll have to draw a line and say everything that happens on the left of this line is not copyrightable, and everything that happens on the right of this line is going to be copyrightable. And of course, this is a completely subjective task. We really don't know. There isn't really an objective way of tracing this line and say, yeah, here on the left, there isn't really that much creative input, so we can't really copyright that. Whereas here on the right, yeah, there's enough creative input, so we can copyright that. There's an important piece of legislation that has been cooking up for quite some time in the European Union. That is called the AI Act. And that is a very stringent regulation of artificial intelligence, its research and its productization as well. This piece of legislation is, of course, going to affect generative music. This legal framework is particularly stringent, as is often the case with EU regulation. There has been an analysis carried out by researchers at Stanford University to see whether foundation models out there on the market comply with the EU AI Act. Researchers have identified different categories that carry some level of rules, like for example, data. So there are in the AI Act rules about data sources or data governance or copyrighted data, and other categories are compute, model, and deployment. There's a web page that hosts all the information about the research here, and of course you can access this material and the slides in the description box in case you just want to review them. But let's move on to the next one. Here you have a summary of this analysis with all the scoring for different foundation models already on the market. So here on this axis, basically you have all the different categories, and here you have all the different foundation models, and for each category they gave a score from 1 to 4. And here you have totals, and down here you also have totals per foundation model. And as you can see, for example, GPT-4 by OpenAI scores only 25 out of 48. So it really doesn't comply that much. And there are other instances of foundation models on the market that score even worse. Like for example, Claude, 7 out of 48, or Luminous, 5 out of 48. So as you can see, there is a huge chasm between the AI regulations in the EU, and this probably is going to pass next year, 2024, and all the models that are already out there in the market. Unlike the particularly stringent legislation that the EU wants to pass, there are other places all over the world which are going to be way more permissive with generative AI. Indeed, Japan has come up saying that you can use whatever copyrighted data without any issue in order to train your models. So as you can see here, there are really different takes and approaches to generative AI. From a European perspective, it's worth to ask whether this stringent AI regulation in the European Union is going to hurt Europe, because people are just going to open their startup companies elsewhere because there's a lot of regulation that's difficult to intake, especially for small startups. But of course, this is a whole other problem, and probably at some point I'm going to address it in a dedicated video. I do believe that what the European Union hopes to achieve is that all the other regions all over the world will somehow comply with the AI Act. And this is what usually is called the Brussels effect. And the point is that Brussels, so the capital of Europe, of the EU, creates some legislation, and then that legislation that's particularly stringent gets adopted by other regions as well, because for other companies to operate within the EU, that's a huge market, they must comply with that EU legislation. And so I do believe that they are hoping to achieve something like this, and something like this already happened, for example, with GDPR, because the majority, for example, of US companies have adopted the stringent rules on data protection that we have here in the EU, given by GDPR. The alternative is that we're going to end up with a two-way copyright world. In the Western countries and regions like the EU and the United States, we're going to enforce quite strong copyright laws, whereas in non-Western countries, the copyright laws are going to be way weaker, and perhaps we may see a lot of researchers and entrepreneurs moving towards these sort of generative AI safe havens. Congrats, you are at the end of today's video. Let's wrap up this lecture by looking at the most important points that we made throughout the video. First, we saw that generative music presents a number of ethical challenges. For example, copyright infringement, musicians' replacement, or the issue of consuming a lot of energy in order to train generative music models. To address these challenges, I suggest we use a number of golden rules, the most important of which is to keep musicians at the center of the equation. Keeping musicians at the center means to be as transparent as possible with them, to ask for consent, to give them control over their data, and to remunerate the data that they give us in order to train our models. We saw that there isn't really a unified legislation for generative music or generative AI or AI at large, and usually legislation will lag behind because of the pace of innovation in AI. Finally, we saw that the EU is coming up with an important piece of legislation called the AI Act that's very stringent, and this may be a way for the EU to be a leader in legislation or in AI, or it could just backfire. That's all for today. Next time, we're going to start crawling our way up towards more technical stuff. And indeed, we're going to look into the difference between symbolic and audio generation. Before you go, please remember to leave a like and to subscribe to the Sound of AI channel if you're not a subscriber yet. Thank you so much for your attention. I'll see you tomorrow.